Time and date.
Okay. Today is Monday, November the 29th
6:40.
at 6:40. Okay, what we're doing today is we're wrapping up the meeting from yesterday. We're going to condense it all together, what we talked about. And then I'll begin with the report about Orla, what we could say about our court case with the Blood Tribe. And I'll just read it to you guys. And Orla said, good day, members. As many of you know, we filed an application in federal court to challenge the consultation process on our cows and plows settlement and trust agreements. Like all of you, we have yet to even see the settlement agreement. Our lawyer is working on confidential order which would allow us to see the document which we have the right to see. The Blood Tribe is refusing us the opportunity to see the settlement agreement so far. As many of you also know, the Blood Tribe and Chief and Council has accused us of being responsible for Canada not signing the settlement agreement. There are a few points of clarification and in relation to the other nations who have settled their cows and plows. Number one, other First Nations have waited approximately 8 to 10 months to receive PCDs following ratification. We are not responsible for the delay even without a court application. Canada needs to go to the Treasury Board for final approval, and this process takes weeks, if not months, based on the nation's experience. Number two, in our view, the reasons for any delay in Council's failure to properly consult our members is in the first place, all other First Nation councils let them see their agreements before ratification. But our Chief and Council did not provide us with the full copies of the trust and settlement agreement. In fact, we have still not seen a full copy of the settlement agreement as of November 28th. Number three, Canada will settle the Blood Tribe cows and plows claim, and it was unfair to threaten that we would lose out on this opportunity. As Chief of Council did, if we didn't immediately vote yes, we had no knowledge of a First Nation who has been denied this opportunity under Treaty 7 or Treaty 8, which has a similar provisions. Number four, the Council did not explain that, like in all cows and plows settlements, the Blood Tribe would finally and fully release our claim to this treaty right. This means that the settlement monies of $150 million is also intended for our future generations. We have seen at least 3 other First Nation cows and plows settlement agreements. All of them released this treaty right. We have no reason to believe that the Blood Tribe agreement is different. Number 5, the settlement details with past, present, and future generations. It is very important that the money put in trust be kept for future generations, but we have serious concerns with the trust agreement, including that 5A, the Chief and Council have made themselves majority trustees, 4 of 7. This means they have full authority over expenses they receive as trustees. This is a conflict of interest, which they did not advise members of. 5B. We know that the trust agreement, which we never saw, allows Chief and Council to spend our treaty and trust monies on pretty much anything they desire. For example, the trust agreement gives the trustees, without any further members' consultations, absolute and unfettered discretion to use our treaty trust monies to pay for any infrastructure, assets, or capital projects, including but not limited to all kinds of projects such as a hockey rink improvements and enhancement of standoff town site. This means that they can spend the money on whatever they want, even if it's not prudent to use of our monies. 6, our case in the application for judicial review in the federal court. A judicial review application normally makes it to a court hearing in approximately 9 months. We filed on October the 12th. We are taking every step we can to expedite a hearing. We know that similarly urgent cases have made it in a course to 2 to 3 months. However, Chief and Counsel are refusing to disclose documents we say are relevant and are insisting that they bring preliminary motions which will delay this hearing, possibly for months, but definitely not yet years, as counsel alleges. If this case takes longer, it will be because of their preliminary motions, not any actions of ours. Most important, we believe that with Canada's consent, council could negotiate the release of the per capita distribution amount. We are not challenging this and would agree that these be distributed without prejudice to our court application. It is councils that chose to make a PCD question, one and the same with the release or treaty rights forever. In our view, these questions should have been separated. We are hopeful that the court will order a new ratification that requires that these questions be separate. Our chief and counsel have been openly attacking us for bringing this case. Therefore, we will not say anything else about the case while it is before the courts. Thank you for listening. Concerned Blood Tribe members, including Lori Scout Eugene and Roger Persican. Further to that, there's a survey that's going to be included in this process. And then, so that is a letter from our lawyer to the people of the Blood Tribe and to all the treaties across Canada that are listed. To begin the process, where is the petition? Right there. This is the petition here. This petition here, what we're saying is survey on cows and plows federal court case. We are asking whether you as a Blood Tribe support our application for judicial review to hold our counsel to account. We have included a full copy of the notice of application filed in court for you to review. We are asking for a new ratification vote and a new opportunity to actually provide input on the settlement and in particular the trust agreement. If you do not support our court application, please complete the survey. Or if you do support our court application, please complete the survey. The questions: 1, are you a Blood Tribe member? 2, if so, what is your name and your status number? 3, as a member, do you support the court application? 4, do you think the Blood Tribe properly consulted members on the settlement and trust agreement? And 5, do you understand that our treaty rights to cows and plows was finally settled by the settlement agreement? So that is the survey. So beginning the process of, just to add on to what's happening with the with the Orla's note in the survey, that is our report to you from the Advocacy group. So I will begin with the, just to add on to the recognitions of rights of discussion table. And at the same time, with the recognition of rights of discussion tables, we are now on the road for a provincial self-control, self-governance. The Blood Tribe, participating Indigenous communities, the Blood Tribe agreed in 2017. And then at the same time, a milestone on July the 5th, 2018, the parties signed a memorandum of understanding on reconciliation. So if you go 18, 19, 20, 21, 22, 23, it takes 5 years to get off the negotiation tables. And but at the same time, with the negotiation tables, what would happen is we have lost our, we'll be losing our sovereignty treaty rights. So as we progress on, we'll let Eugene and Chris explain that more with the white paper. And one more on this whole thing is like, this one is what I'm looking for. I want you guys to understand the historical process of what we have gone through as First Nations. The long-term goals set out in the government policies and legislative initiative listed are not new. They are old as the Indian Act and articulated in 1969 White Paper on Indian Policy, which set out a plan to terminate the Indian rights. So the government has always been after us to lose our sovereignty. The termination plan of Indian rights in 1969, the White Paper began. 1980, the Buffalo Jump Paper. In 1992, failure of the Canadian constitutional reform. And in 2019, the White Paper 2, Trudeau government creating a new relations with Indigenous people, recognitions of rights of discussion tables. Within our leadership, the Blood Tribe attempts for recognition of a rights table began. In 1996, the claim was accepted, and again there was a failed final agreement ratification vote in 2012. So then again in 2016, when Roy got on Chief and Counsel again in 2016, in 2017, when discussions began by Chief Roy Fox and Counsel White Paper 2, Trudeau government creating a new relationship with the Indigenous people, recognitions of rights and discussion tables. July 5th, 2018, the parties signed a memorandum of understanding on the reconciliation of Canada and the Blood Tribes to celebrate the key steps on the path of renewal and reconciliation. There will be ratification votes will follow when we get off the negotiation table on 2023. So again, this is information that the people have to understand is the extinguishment of our treaty rights. So that is my beginning of the presentation from yesterday. So, Chris?
Yeah, I'm going to be reading from a document I used last night, and it describes in more detail what we have just heard from Roger here. And what it is that it's a bit of background on this national top-down two-track approach. In December 2015, when Prime Minister Trudeau got into office, he made an announcement about establishing a two-track approach to Indigenous policy. Number one, there was closing the socio-economic gap between Indigenous peoples and non-Indigenous Canadians. And that's closing down of the Indian Act programs. Number two, making foundational changes to laws, policies, and operational practices based on the federal recognition of rights to advance. And this is the federal interpretation of self-determination or self-government. In other words, we can talk about self-government, but it's not our implementing our cultural values. It's going to be another form of an Indian Act. That's all, it's just got a new title. So the mandate letters of the two ministers who are in that time was Indigenous Services and Crown Indigenous Relations, set out the original views and outlines of a national reconciliation plan of the Trudeau government that can be seen to revolve over the past 4 years and into 2 tracks. The federal government expanded on its National Reconciliation Plan in 2017. Roger just mentioned that's when we got on the table to start discussing this. That's when our blood tribe entered the picture. And they issued 10 principles on a relationship with indigenous peoples and dissolving, splitting Department of Indian Affairs. The federal 2-track Indian Act versus self-government approach to indigenous policy is now being implemented through the following elements. This is how they're going to implement it. It's the top-down approach with the 2 MOUs with AFN. A bilateral mechanism. This is an AFN Federal Cabinet Committee where the AFN National Chief and Prime Minister meet annually, and AFN delegation meet federal ministers semi-annually on shared priorities as set out in the AFN Canada MOUs. Now, as a former chief, and Chief Roy and previous Chief Charlie will agree, Blood Tribe has never been a full supporter of AFN because there's some major problems we have in their charter, but we never have. But here we're allowing them to speak on our behalf, and that includes our treaties. A working group of ministers on the review of laws and policies relating to indigenous peoples. Supposedly this working group was to decolonize Canada's laws and policies. During a July 2018 cabinet shuffle, a cabinet committee on reconciliation was created by the Trudeau government. We had 2 ministers at that time who quit the Liberals. We don't know what's being said in there, but they quit that task force. And one of them was Judy Wilson-Raybould, an Indigenous lawyer and a member of Parliament. She quit the Liberals, and the other one was the former health minister that walked away. Because there's something in there that's being discussed that really, they just drove them away from the Liberal, because that's how they were. And I would imagine as I continue reading, you'll soon get the feeling what it's all about. 10 principles respecting the government of Canada's relationship with Indigenous peoples. On July 14, 2017, issued 10 principles. These 10 principles are central to the federal reconciliation agenda and amount to preconditions in the development of federal policy and law. Dissolving, splitting Department of Indian Affairs and Northern Development on August 28, 2017, Prime Minister Justin Trudeau announced the federal government was dissolving the Department of Indian and Northern Affairs, or Northern Development, and creating 2 new federal departments, one for Indigenous Services and one for Crown Indigenous Relations. This federal restructuring of government is central to the Trudeau government's 2-track approach to Indigenous policy, law, and in defining a new relationship with Indigenous peoples. On April 8, 2019, the Trudeau government introduced an omnibus budget bill of Bill C-97 into the House of Commons, and buried within Bill C-97 is legislation to create the 2 new departments, Indigenous Services and Crown Indigenous Relations, in law which the federal government is trying to pass before Parliament and which has already been passed. You got to remember this is 2019. This paper here is about 2 years old. Recognition and implementation of Indigenous rights framework. Now we're getting into the interest areas which Roger was talking about. On February 14, 2018, Prime Minister Justin Trudeau announced his federal Liberal government intended to introduce a bill into Parliament regarding a recognition and implementation of rights framework in 2018, and that he wanted it to become law before 2019 federal election. The core of the planned federal legislative framework was to transition bands currently under the Indian Act, such as ours, into self-government. So we're all being herded, the First Nations across Canada, we're all being herded into this self-government. or into a self-government agreement or a comprehensive claims agreement, modern treaties. Now, we've just learned that the big land claim, the federal judge has awarded us that victory. Now, does that mean that our chief and council have to enter into the self-government before that big claim is ratified? These are questions we need to have answered. Which Prime Minister, Justin Trudeau, has called a fourth level of Indigenous government with a lower status than municipalities? Now let me explain this. The first status is the Government of Canada, federal parliament. The second level is provincial members of Legislative Assembly. The third level is the municipal government, such as Lethbridge Mayor and Council, even the village of Glenwood. That's the third level. It will be at the bottom of the list. We'll be at the fourth level.
Yeah.
At the bottom of all these governments. So that's how serious. Instead, our treaties were nation to nation. Now we're just a doorstop for some of these. So in September 2018, there was a widespread rejection of the federal proposed framework by chiefs and First Nations across Canada. This resulted in a delay in proposed framework legislation being announced in the CBC News report, November 18, 2018. While the CBC News report didn't mention what was the content of the statement from the offices of the Minister of Crown Indigenous Relations, which were also released on November 14, 2018. Attributable to the Minister's office. Our government is committed to advancing